Hello, everybody. Welcome to the Power is Now Real Estate Roundtable. My name is Eric Frazier. It's a beautiful day in Southern California, a great day to talk about real estate, and that's what we do here on the Real Estate Roundtable. For over 16 years now, we've been talking about developing real estate, buying, selling real estate. The Real Estate Roundtable is a show designed for real estate professionals, people who are interested in just being more than a real estate agent and a broker, but a trusted advisor, providing opportunities, business opportunities, strategies to help their clients grow their net worth, to acquire more real estate, and perhaps as a trusted advisor to extend opportunities to their clients to further develop their wealth. Today, we're going to be talking about syndicating real estate, and that's a scary word if you haven't heard of it before. And if you have this tendency to be kind of afraid of doing things at a very high and technical level, well, we have someone here today that is a specialist in syndication, and his name is Doug Ruark, and I'm going to share his background in just a few minutes. But before we do, I want to encourage you to download the Power is Now TV app. It's available on Android and also on iPhones, and you can find us on Apple, Roku, Fire TV, any of the streaming platforms. And there you can find other shows about real estate on the Real Estate Roundtable, the Business Roundtable, and there are other shows that we have in which we talk about the business of real estate. We are leading the conversation about real estate here at the Power is Now, and it is just, I have the best seat in the house in bringing industry leaders and experts in real estate to the table to talk about what they know and to help us really understand what we need to do as real estate professionals to better serve our clients and to build wealth. Well, today is Douglas Ruark, and he's the president of Red Rock Securities Law and Red Rock Investors Technology, Inc. Doug has over 30 years of experience in corporate finance, syndication, security compliance. He's helped clients complete more than 5,000 offerings and built an alternative business structure law firm to deliver legal, operational, and tech solutions under one roof. Doug, thank you so much for taking time out of your busy schedule to join us today on the Power is Now Real Estate Roundtable.
Oh, thank you, Eric. And it's a great pleasure to be here.
Doug, we have a tradition on all of our shows where we ask our guests the power question. And that is in the context of what you do professionally and who you are personally. What does the phrase, the power is now, mean to you in the context of what you do?
Well, I think in the context of what we do, we're really here to provide solutions, for clients to go execute a capital raise. And I think, it really kind of is that first step. So when I think of the phrase, the power is now, a lot of it really comes down to entrepreneurship and taking that first step. If you talk to a lot of entrepreneurs, what they'll say is that maybe that first step was the hardest, but they'll never regret it because ultimately it put them down a certain path. And so I kind of look at our role in the process as really being that first step, that if you're going to go raise capital to acquire a real estate asset, for example, and you're going to be bringing investors into your company to execute on that goal, that really we're going to be essentially the first step there, that there's going to be some legal work and SEC work that needs to get done to make sure you're doing that properly. So I think, for me, it's the what I'll call the first step principle, which is, taking that first step towards reaching that goal.
And I like that. That reminds me of just a number of things, but the idea that that first step is always the hardest step. We procrastinate or we allow fear to rob us of taking that first step because we don't know enough or we don't feel that we are qualified enough, or all those things get in the way, right? And taking that first step.
Oh, absolutely. And I think, I think that's why I have such great respect for entrepreneurs and just entrepreneurship in general, because, when you look at somebody that's been able to build a business and you invariably hear their backstory, the early days, there's always some of those challenges that they faced. So I think being the position I'm in, I get to deal with entrepreneurs and business owners every day, and I love hearing their stories. I love hearing what they went through to build what they've created, and I also love just the creativity that a lot of times they'll bring to the table in terms of creating a business. So,
Doug, what does it mean to you personally? The power is now.
you know, that's a good question. I'm a big believer in really squeezing the juice out of every day. I mean, I think ultimately, every single day we're granted with the gift of being alive. And
Mm.
when you think about it from that standpoint, there's no better time to go ahead and put the accelerator down and start, working towards your goals and your dreams. And I think a lot of people, like you just said, sometimes it's fear or lack of knowledge that maybe prevents them from taking that first step. So for me, a lot of it comes down to, in a way, you're not guaranteed a tomorrow. So go ahead and take that first step, start making your dreams a reality, whatever that may be. You're running a tech company, you're trying to syndicate capital for a real estate asset, you're looking to do a development project, whatever it may be. Take those steps now, and there's no better time than now to start moving towards those goals. And I think too, step by step, you know you don't need to go from the end zone to end zone in one step. You take it step by step, and so I think for me personally, that's kind of how I approach every day. Is I wake up and I feel blessed to be alive and get to come down and walk in my office and do what I do every day.
Doug, thank you for those great power is now statements. And uh, everything you said resonates with me. It is truly a blessing to be alive and to be able to seize the opportunities that are in front of us right now. In fact, this is a great segue in terms of what you said in regard to, what it means to you professionally, taking that first step. You are an entrepreneur yourself. You had to take that first step. You're the CEO of a law firm that specializes in securities. And so, can you take us through the journey here to you getting into corporate finance and starting your own law firm?
Yeah. Well, it really started when I graduated from college. I actually did go into real estate for a short period of time, and then I really then stepped into creating a company that was there to broker alternative commercial financing and commercial loans. And that really kind of put me into kind of the general business of finance. I then took a position at a company where we started. They worked on developing private placements and private securities offerings, and then that really kind of then launched me into creating Regulation D Resources in 1999. And really, the goal of that company was simple. It was to democratize access into creating offerings and getting SEC filing work done, and really serving essentially as an advisory company to get entrepreneurs through that process. And that was a very successful business. We operated for a long time under that business model. In 2015, we added a technology component, which is the investor raise portal builds, and then ultimately in 2021, we started exploring moving into becoming a licensed law firm. And Arizona had created an option for non-lawyers to be able to own a law firm so long as they're removed from the delivery of the legal services. And that ended up being a great option for us just because we did have lawyers on staff, but they worked internally at the company. They were there mainly because of their knowledge and education in terms of being able to create SEC filings. So it just ended up being a great fit because then it just expanded our ability to provide services. And most of our clients up until that point, they were usually coming in with their own, corporate or business counsel supporting them. So I think being able to morph the business into becoming a law firm with a technology component to it, it just ended up being a perfect fit for us, and obviously allows us to even further democratize access into these programs. I mean, that's a big core mission statement for our firm, is to try and keep fees reasonable for entrepreneurs and business owners that want to come through and do an SEC offering and raise capital properly.
So describe your company today. How many lawyers do you employ and the volume of transactions you do? And you have a singular focus on this practice of law of syndication, right? I mean, you don't do personal injury and, corporate litigation, that kind of thing.
Yeah, I like to say we're a securities focused firm. I mean, we do have the ability to do corporate work, and in certain cases, we may be doing corporate work for a client. Corporate work to me would be things like forming an entity or drafting bylaws. But the core focus of the firm is securities work, creating securities offerings under the SEC exempt programs primarily, which is Regulation D, Regulation CF, and Regulation A. Right now we have 5 attorneys along with a compliance attorney. So 6 attorneys essentially on staff supporting the company and its operations. We obviously have other individuals on board, marketing, office infrastructure, office managers. And then on the technology side, we created Red Rock Investor Technology, and that really works hand in hand with the law firm to build the raise portals that administer the raise. So that company is there to essentially bring the technology solution for managing the securities offering.
Doug, I'm really glad you're here because I love what you said earlier about democratizing, I guess, the ability to, form syndications and to educate people on how to do it. And one of the reasons why I send invitations to a number of people for this show today is that they're all leaders. They're all looking for ways to add more value. And as a real estate broker myself, I'm always looking for strategies that make me stand out, something that I can offer either through my experience or access connections that others don't have. And syndicating real estate and understanding that is, on one hand, it seems simple, but on the other hand, it seems very technical and very difficult. And when you say democratizing, you're really speaking about the educational component of this, right? And making it accessible to everyone to do.
Yeah, I think it does actually, the term democratizing access into these programs, I actually do think it covers a little bit of ground. I mean, initially for me, it is the demystifying the process. And, there's a lot of bad information, I would say, that floats around some of these communities, real estate, energy, oil, and gas, as far as, when do you need a securities offering? What does the process look like? What do the costs look like? But I think the other thing is just fees. Being a firm that focuses on this, we work hard to obviously keep our fees reasonable. And part of my goal there is to just build a client base that is, continually coming in and bringing us business because we've treated them fairly as far as the fees go.
Who is your typical client? Are they real estate agents or developers? Are they real estate investors?
On the real estate side, it does cover some ground there. I mean, real estate developers who are doing projects, infill site development projects or, planned communities. We certainly do a lot of work with real estate fund operators. They're, putting in place real estate funds to acquire assets. We do a lot of work with people where it's their first offering, where they've maybe been in the property management side and, now they want to syndicate capital and start managing assets. So, for us, it really kind of covers a lot of ground on the real estate side. We get experienced people coming in where they've done offerings before, and we also have people where it's going to be their very first time going through the process.
So, Doug, we have a special audience today for today's show, and we have some questions in regard to your background. The first is Guy Allen out of Virginia. Welcome, Guy.
Well, thank you. Yeah. I'm Guy Allen with eXp Realty in Virginia. And my question is for the layman. What exactly is syndication and why would somebody want to syndicate?
Yeah, I mean, I think, it's funny because the word syndication can get used in various ways. To me, it's really coordinating capital coming into an entity to purchase a real estate asset. So when I think of syndication, I think of it as actually syndicating capital to acquire an asset, execute on a development project. So it kind of is the industry term. In essence, it just means that you're raising money to either acquire or develop assets.
And the second part of that was, why would somebody want to do that? I mean, the syndication, is it a group of people coming together to have more buying power, or exactly why would somebody want to syndicate when they could just buy it on their own or something like that?
Sure. Well, a lot of it would be being able to expand the portfolio faster if they're not just organically using their own capital. So, if they're able to go raise $30 million in equity, and they're going to go purchase self-storage facilities, that's probably going to outstrip the capabilities that they may have internally had. Maybe they had $5 million in operating capital. So really, it would be just being able to expand faster as far as your portfolio, or execute on larger projects. And then some of it may just be that the sponsor or developer wants to limit their capital exposure. And in that regard, then, bringing in outside capital from investors is going to allow them to do that, where now maybe they're putting in less capital than they would have had to if they hadn't gone and brought in capital from investors.
Thank you.
Great questions, Guy. And folks, there's a whole lot more in talking about syndication and the regulations and compliance and putting together a syndication. And we're going to get into that. We're going to take a quick commercial break. You're watching or listening to the Power is Now Real Estate Roundtable with Doug Ruark, president of Ruark Securities. We'll be right back right after this commercial break.
Everyone knows the power of social media and the impact a strong online presence has in this day and age. But most real estate agents simply do not have the time to manage all the advertising and marketing details, and that's where the Power is Now Media steps in. We are the answer you have been looking for. Let us help put your brand on the map. We will create customized graphics for weekly full-page ads, social media content, video, and podcast content for you. Sound complicated and expensive? It is affordable and easy. We have the best experts on the job. Go to thepowerisnow.com and find us under the VIP Agent tab to learn more. This is the future of real estate. Join today. thepowerisnow.com.
And we're back. Welcome to the Power is Now Real Estate Roundtable. My name is Eric Frazier. Today we're talking about syndicating real estate. And it may sound like a fancy term, very technical, but we have someone here who's breaking it down for us and making it easy. And why? Well, if you're a real estate broker, you might be thinking about, how do I add more value to the hundreds, if not thousands, of relationships that I've had over the years of people who are always asking me about, investing in real estate, or maybe they want to buy real estate. They want to buy an income property and they want me to help them. Well, I want to do more than just help, right? I want to be maybe part of the deal. I want to, hey, let's do something together. That's form of syndication. And so that's why Doug Ruark is here, and he's the president of Ruark Securities, a securities law firm, and they specialize in syndications. And so far, he's given us his background. And Doug, I really appreciate you taking the time to join us today and to educate us. And I certainly hope those who are listening or to the podcast or watching, that they'll reach out to you to get more information or maybe start their own syndication. So now we're getting down to, the nitty gritty, if you will, the regulations and the compliance and the rules. And Guy Allen really just kind of kicked it off for us with his questions about what is a syndication and why would someone want to, give their money or put their money in a syndicate as opposed to doing it themselves. And I thought your answer was right on point. It's about expanding your capabilities, right? And being able to do more.
Yeah, absolutely. And, a lot of it really just does come down to either, wanting to do larger projects that's going to outstrip your ability to put your own capital in, or maybe you don't want to have that much capital sitting in one project or one asset. Like I said, a lot of it just comes down to growth of the business, that as you do these offerings and you build relationships with investors and you have new projects or new acquisitions that you're doing, you've built then an affinity base of people that are going to support you, so long as they've gotten what they expected, obviously. But I mean, if you're a good real estate operator and you're keeping everybody happy as far as your cap table of investors, then they're going to want to participate with you in the future. And I think that's a core piece of this, is building that foundation under your real estate business as far as people that are willing to put capital into new projects or new acquisitions.
When you are starting a business, Doug, and I think this applies to all businesses, so whether you're selling insurance or investments, or cars, or real estate, you just got your license, you're getting into the game, you go for that low-hanging fruit, which is family and friends, right? And even as you get more established and you're doing deals and your family and friends, they know you, they like you, they trust you, they're willing to give you money, but it can get complicated in using other people's money, especially from family and friends. There's still laws that apply. So take us through, you know, let's say the easy money, family and friends, to why every single syndication is regulated as a security, regardless of who the participants are.
Well, Eric, it's a great question, and I think ultimately I always like to start these segments by saying the SEC doesn't have the term friends and family in their lexicon, meaning the process for raising capital from investors for a real estate acquisition, for example. If you look at that, you're going to have a sponsor. They've probably created an LLC. They're going to probably be selling membership interests. If they're raising equity to the investor class members that are coming in. And ultimately, for the SEC, their concern is making sure that that process is getting handled properly and in compliance with the applicable rules. And whether it's your best golfing buddy or your cousin that's investing, that's immaterial really to the SEC. Their concern is making sure that the appropriate processes have been followed and the rules have been followed for executing that security sale.
Wow. So if mom or dad just, sitting on a couple of $100,000 and they just want to say, Eric, invest this for us, am I breaking the law by taking their money and doing it? Or am I just creating risks for myself if the SEC finds out about it?
Yeah. I mean, again, I've always said that really, if you're dealing with friends and family, I mean, you really want to go above and beyond. You want to make sure you're doing everything properly. The last thing you want to do is burn a relationship with someone where they invested with you and maybe the asset turned out to be a bit of a failure and maybe there was some loss of principal capital and what have you. The last thing you want to do is have friends and family or anyone really feeling like they didn't get full disclosure or you didn't handle the process properly. So, that's where I kind of default to, get good legal advice and, make sure that you've got a good lawyer and law firm supporting you through that process to make sure that you don't run afoul of those rules and to make sure you're doing everything properly to protect yourself and your company, but also to protect the investors as well, making sure they get full disclosure and they understand all the appropriate risks before they invest.
So can you give us some examples of some maybe missteps that people take in trying to raise capital? How serious is this? Do you know of any kind of news reports that the SEC or the government is cracking down on, investment? Because you see a lot of it online, by the way. A lot of people are doing things.
Yeah, well, let me say that, you actually have, two primary regulatory bodies that can certainly come scrutinize security sales. There's certainly the SEC at the federal level, but you also have state regulators that with state securities commissions that will review and analyze security sales activities. I think as far as, what are some of the missteps? I mean, one of the biggest and probably most prevalent is just ignorance that there are rules that apply to this. Hey, we have an LLC, we're a private company. What does the SEC have to do with us? We're just going to sell some membership interest to 20 people and raise some money. And they just don't either, they didn't get proper legal advice or they just don't understand that there are rules that apply to that. And I think one of the things that I've seen that's unfortunate then is if there is some type of action, a state regulator doing a cease and desist action or, the SEC investigating and maybe there's a fine or something. I mean, that's almost always going to typically be a public event, meaning 5 years later, you're now doing it properly, raising money. And, you've got a proper offering in place. And Doug, as the potential investor, drops your name into Google to do a little bit of Google due diligence and up pops, the state of Pennsylvania had a cease and desist against this guy 3 years ago for unregistered security sales. It's just a bad look. Even if you were able to escape that with minimal damage and fines, for example. I mean, a lot of times they always like to say the internet's permanent. So I feel like part of it also then comes down to protecting your reputation, that as you move forward in your real estate business or any business where you're raising money, but especially real estate where you're probably going to be raising money multiple times in the future, being able to protect your reputation so that when people do a little bit of research on you, that sort of stuff is not coming up, because it kind of immediately signals then, are they really doing things properly? Do they really understand what they're doing as far as managing their business? They didn't even raise money properly apparently 3 years ago. So I think that'd probably be one of the biggest, is just ignorance of the fact that there are rules that apply to this, and then unfortunately there could be reputational damage in the future if you do have a state regulator or the SEC come in and find there was fault in how you raised capital.
Now, if I were to form a syndicate, I would first want to know who's really interested in and just working with me to acquire, multifamily assets. Would there be anything that I need to know just to put it out there? Say, hey, you guys, I'm thinking about forming a syndication, raising, $5 million. If you're interested in working with me and doing something like that, please complete the form. Click on this button. I'd create a video or something, and click on the button and let me know. Is that technically an offering? Would I need to say more than just, hey, I'm trying to put together a list? Give me some idea and just really how to kind of lay the groundwork or the foundation. Like building a house, right? You need to first, build the foundation.
Yeah, and I mean, you do step into some nuance there, because it really does come down to what do those communications look like. I mean, if it's just a general sort of promotional on your business and you're maybe potentially looking to put a fund together at some point and, would people be interested? You probably would be fine. I mean, again, it is going to come down to the specific language. And I would say then that's the law firm's responsibility to give you guidance there. There are testing the waters provisions in a lot of these programs where you can test the waters and actually test the waters with, securities terms being out there. But again, there's protocols to that and specific rules to that. So I would say then really, if you are interested in doing that, part of it would be working with your law firm to make sure that any communications that you're putting out aren't going to be deemed an offer of actual, an offering where you're actually offering for people to come purchase securities.
So then, what would be your recommendation I've never done this, and this is something I've thought about for years, and primarily because I'm always approached by people who want to give me money to invest, or they want me to help them invest their money, and it's always on the come, right? I mean, you put in a lot of time and work, and sometimes it never comes to pass. So if I were to do this, I would really want to know who's real and what their capabilities are. So if you could kind of paint the picture, you can use me or maybe use Julia, but paint the picture of us getting started. Say, okay, because here's the thing. This show is for real estate professionals, and we're going to have thousands of real estate agents and brokers watching this. And they're thinking, I'm saying, listen, we need to be more than just sellers of real estate or representatives of buyers. We need to be more. We need to be trusted advisors, helping people to invest their monies, to increase their return on their investment, to build wealth. And we need to make money. I want to make more than the 3 to 4% commission on a listing or a sale. I want to be a partner or participant in the revenue of an asset that I help someone create and build. So how do I get started? I know the first thing is I need to retain you to help me put together some compliant language for getting that message out to my potential investors who want to be with me, who want to join me on this journey.
Yeah, well, and I think a lot of it comes down to what are the goals of the client as well. Because, for example, if you're looking to raise money for a specific single asset, um, there's going to be a certain process for that, and a lot of times there's really not going to be a lot of time to necessarily go out and test the waters. And what I mean by that is if we're going to create a securities offering with a named asset, it's 123 Smith Street, and it is a 30-unit multifamily property. You would have most probably have to have had put that under contract to have it under control to go raise the money for it. So I think a lot of it would come down to the actual type of offering and what is the forward plan. And the flip side to that would be, let's say that Eric wants to put together a general multi-asset real estate fund, that Eric has specific specialization in self-storage assets, for example. He's phenomenal at self-storage, understands the market, understands the financial dynamics, and maybe puts out something that is more of a general, hey, if we were to put a self-storage fund in place, I'm just kind of interested in seeing who would be on board with us and would want to participate with us. Because with the fund structure, normally you're not going to have assets under contract yet, so you're really not under that time frame pressure. It gets more interesting when there is a contract in place because there's only so much of a due diligence period. So there's ways then, obviously, where we try and expedite the process in those situations. And sometimes it's actually getting the client to engage us prior to even putting the asset under contract. Meaning, hey, Doug, we have 3 self-storage facilities we're evaluating. They're all in the Austin, Texas market. We haven't put one under contract yet, but we're definitely putting one of the 3 under, and we're going to need to raise money. Great, get us started. Because I think ultimately there's a lot of work we can do to lay the foundation for that raise without knowing the exact asset. And then we could get 70% down the line with a lot of the legal work. Then it's okay, we've got the asset under contract now. Now we've cut that time down to finish that securities offering and have it ready to go to market versus starting from ground zero. So there's a lot of little tactics that we've kind of developed over the years, especially with the real estate operators, and especially because a lot of times they are under some time frame pressures if it is an asset that they've already put under contract.
Wow. So there's 2 scenarios then. One where you do have the time to find the investors, get the interest in a general fund. And one where you see an opportunity and great opportunities don't last long. So you'll have to put up some money to at least get it under contract. And you'll have to have a long enough contract so you have time to, get the securities offering done and to raise the capital. And this kind of reminds me in residential real estate, people who are buying HUD foreclosures and they need a 203K. And unfortunately, because you have to get, a feasibility study and the HUD counselor out and a whole bunch of people, instead of being a 30 or 45-day transaction, it could be a 90 to 120-day kind of transaction. And, HUD or the seller, if it's not a HUD property, may not want to go that long. How do you deal with the timeframes? How do you negotiate the timeframes to have enough time? Or what is the timeframes? What do we need to know in terms of the time it would take from the time I say, hey, Doug, I got 123 Main Street. I got it under contract. I need to raise money. I got to close in 90 days.
Yeah. Well, I would say this, this starts driving into what type of offering is being put in place. You've got Regulation D, you've got Regulation CF, and Regulation A. Those are kind of the 3 primary programs that most people would fall into as far as raising money. The benefit with Regulation D is it would be the most streamlined to prepare. It's also got the least amount of compliance associated with it. You're also not waiting for the SEC to qualify the offering. So if it was a Regulation D, for example, and I had a really motivated client, I mean, we've had Reg Ds in place in the span of, handful of weeks before. So it is, one of those things where if the client's really motivated and responsive in working with us, sub 30 days to put a Reg D in place is possible. And I think, again, that really then just comes down to if I've got a client and they're looking at purchasing a specific type of property, ideally, I'd like to get started on the legal work before they put it under contract so we can get a head start. Because there is certainly things that we can do to start building out the legal work prior to them actually putting the exact property under contract. I would also say this, a lot of it depends on where that real estate syndicator or operator is in their career as far as raising money. Because if it's an operator that's done a lot of raises in the past and they've got a big affinity base, they're going to have a better chance of hitting their timeframes, because they may only need a couple weeks to raise the money. Hey, I've already got 1,500 people that regularly invest with me, and I'm probably only going to need about 100 of them to invest to finish the cap stack for this acquisition. Versus maybe the newer syndicator where they don't have that affinity base yet, where it might take them a little bit longer to get exposure. And I think too, there are ways to do blind asset acquisitions where we're going to acquire a self-storage facility that fits this certain, box as far as, geographic location, size, asset acquisition cost. But we're going to raise the money first. And then once we've got enough money in hand to acquire the asset, from there, we're going to then select that asset and put it under contract. And I use the term blind acquisition just because that is really kind of the technical industry term for it. But the investors understand what you're getting ready to purchase. It's going to be disclosed to them, the type of asset, the market, whether there's going to be any senior financing involved. So again, I think this is where bringing a firm on board and I think too, developing a relationship with a firm that has a focus on creating this type of legal work and getting people through this process is helpful. Because for me, if I've got a client where we've already done work with them before on the real estate side and they understand the process, that also makes it more efficient. So they know coming in, well, I know what the Red Rock team is going to need to get me through this process and get me out raising capital. So a lot of it depends on, who we're working with and where they are, and obviously the complexity of the project. When you start looking at Reg CF or Reg A, your timeframes get longer. CF, you've got a broker dealer involved, you've got a transfer agent involved, you've got more involved payment rails being built in. So it does take longer, minimum 60 days, in my opinion, for that. And then Reg A, which is the most sophisticated offering you could really put in place, that one is more of it's basically an S1 filing we're drafting, and then it does need to be submitted to the SEC and go through a qualification process. So usually you're probably not going to see Reg A for a single asset acquisition unless that sponsor has it under control for a long period of time, or it's a situation where maybe it's a related entity sponsor, an affiliated entity to the sponsor selling it into the fund, for example. Because Reg A, you could be 90 days on the legal work and then another month to clear SEC if there's, if everything goes smoothly with their qualification process.
Now, Doug, you just took us to the graduate level of corporate finance and talking about Reg D, CF, and Reg A. And we're going to address that in segment 3. But I want to take you back to my original question, and you kind of answered that, because I like the idea of the blind offering, saying that, listen, I'm going to focus in on multifamily units, 50 units or more, 100 units or more. And I want to raise capital. The typical 50 unit, depending on what state you're in, could be $2 to $5 million. And I want to take them down. I want to clean them up. I want to increase the rent, and I want to turn around and sell them. That's what I want to do. So I want to be able to paint the vision. And then raise. I mean, I love what you said, that people who have been doing this, they have 500, 1,000, 1,500 people that have invested with them. So literally in a phone call or an email, they could raise 2 million, 3 million, 5 million. Well, I'm here to tell you, Doug, that, I know a lot of people, myself included. I've been in the game for 40 years. I have a real estate firm, same location, downtown Riverside, 17 years. I want to be able to leverage the reputation and the notoriety that I have, and that all the agents that even on this show right now have, where people know them, like them, and trust them, so that we can get out of the day-to-day grind of traditional real estate and become advisors and helping our community of investors invest. And so the blind trust idea, if you could just elaborate a little bit more on that, because I think that is something, it sounds like an easy play, and your involvement would be more so on the marketing side and compliance end. so that we can just begin laying the foundation?
Yeah, I would say we'd be on the legal side as far as preparing the offering and getting everything structured. But I think when you look at most, like for example, most of the real estate funds that we do, they tend to be they're tend to be blind blind pool entities, meaning it's going to go acquire real estate assets. It certainly disclose the type of asset, the market, what's the underwriting strategy for the assets, the vetting strategy, what's the investment management strategy, once it's acquired. But there's some benefits to that in that number one, there's usually not the time frame issues because the sponsor or fund manager has not put an asset under contract yet. They're going to wait until they've reached a minimum level. Okay, we need 5 million for each asset purchase, so they're going to wait until they got 5 million. Okay, great, we've got 5 million in hand. Now we have the ability to take down our first asset, and they're probably going to have a wish list. They're already out on market looking at assets, so that they'll probably have 2 or 3, maybe more that they've already done some vetting on. So you kind of eliminate the time frame issues there versus I've got this under contract and I've got to raise the money and close this thing in 90 days. But I think the other thing is that if you continue raising money into that fund entity and that fund entity is now purchasing multiple assets, you're creating diversification for your investors. So let's just say that now you have 10 assets, maybe one of them underperforms, you have 9 others that are going to be there performing to take up the slack. So you kind of create then a diversification of risk for the investors because now you have multiple assets. And I think, again, you do eliminate then in that situation the timing issues. And like I said, we certainly do plenty of single asset acquisitions where they're under contract and, there's a time frame to hit. But again, there's some strategies then to be able to mitigate that. So I think then, from there, what the client, what Eric's really bringing to the table is the experience. Hey, I've been in this business a long time. I know this specific market. I know this specific asset class. A lot of times it's the connections on the purchase side. I'm tied in with banks. I'm tied in with sellers. I'm tied in on being able to get access to off-market listings that everybody else isn't going to know about. So, and then when you start looking at, value add, I've got a great core group of people that are going to be able to come in, contractors and service providers to do a rehab and do it on budget and instantly then create some value within the asset.
Wow, Doug, I'm loving this, man. I'm loving this. We have, again, some special guests here with us today, and we want to give them an opportunity to ask a question before we go into segment 3. Where we're going to deal more closely with these regulations you're talking about. So let's bring our first question to the table. So our first question is from Guy Allen out of Virginia. Again, Guy, your question.
Yeah, Doug, it's a wealth of information. You told me a lot of information about how to avoid the pitfalls, those pitfalls to avoid. But could you tell me what is the biggest mistake that people make when they're setting these up? I know you want to talk to a professional, but what's the biggest mistake? Because I want to avoid those pitfalls.
I would absolutely say it would be not putting in place a proper securities offering and making the appropriate filings and claiming an appropriate exemption. So that it just ignorance that it applies to them. And again, I can understand it. It's a private LLC. I'm just going to 20 people to raise some money. I'm going to have them sign an operating agreement. But what does the SEC have to do with this? So I think that would be, to me, probably the number one pitfall is just complete ignorance that there are rules that apply to this and a specific process to go through to do it properly. And some of them, I'll say it's kind of like speeding on the highway, right? Sometimes people, they'll do it for several transactions and, maybe their investors are happy and no one's placed a call to a state regulator and regulators don't find out about it, but it still doesn't mean they've done it properly. And part of what I look at as well is what happens if something goes wrong with the asset? Now people have lost money and now they're going to go hire a securities attorney to look at, well, what documents did you sign to tender this investment to this company? But I would say the number one issue or pitfall would probably be the fact that a lot of these real estate operators just don't realize that these rules can potentially apply to them.
Thank you.
Next up is Abraham Williams out of California.
Thank you, Eric. Doug, thank you so much. Again, a wealth of knowledge, and Eric already stated that we, as real estate brokers and agents, we want to expand, right? We want to get out of the day-to-day of just, doing real estate. We want to grow our investments. And one way to do it is obviously to have syndications and investments and go after units. One of the things I want to know is, what's the difference between accredited and non-accredited, right? We hear those things, accredited and non-accredited investors. And when you're trying to build a portfolio, you're brand new, you're a sponsor, you create the syndication. Which one would be better to pursue? Does it depend on the size of the asset or I'm just trying to figure that portion out.
Before Doug answers that question, you actually jumped right into segment 3, because I think that Doug is going to go into detail in that. The different regulations do require different types of investors. And so with that, that'll be a great segue to our commercial break. For those of you who are watching, thank you so much. This is the Power is Now Real Estate Roundtable, a show dedicated to real estate investment, real estate, building wealth in real estate. It is for real estate professionals. It is for consumers who are investors, people who are looking to just take their portfolio, their business of real estate to the next level. We're going to take a break, and when we come back, we're going to deal with Regulation D, CF, A, and Doug's going to talk about accredited and non-accredited. It's going to get deep. As you can already see, it's a deep topic anyway, and I'm so happy he's with us today. Stay tuned. We'll be right back right after this commercial break.
The Power is Now magazines are the leading resource for real estate agents, mortgage bankers, entrepreneurs, and small home ownership businesses, providing leaders with business strategy information, resources, and tools through PIN, Real Estate, Programming Guide magazines. Stay up to the minute with real estate news and information from industry experts. Subscription is free. Sign up today. thepowerisnow.com. thepowerisnow.com.
And we're back. Welcome to the Power is Now Real Estate Roundtable. My name is Eric Frazier. And folks, I love the Real Estate Roundtable. For the last 16 years, I've been inviting industry experts in real estate and finance and banking and marketing to talk about, the business of real estate. How do we grow? How do we make more money? How do we better serve our clients? How do we invest? How do we raise capital like we're doing today? How do we elevate ourselves beyond the traditional day-to-day grind of representing buyers and sellers? Well, it is representing an investment fund, syndicating, helping others make more money, pooling resources together so that we can also, as professionals, participate in the wealth that's being generated, and we can help our clients continue to build wealth to achieve their goals. With us today is Doug Ruark, and I keep saying his name wrong. Let me say it again, Doug Ruark, and he is the president of Ruark Securities, a securities law firm with a singular focus on securities, helping people create syndications and doing all the legal work that's required to have a syndication. And so far, he's been doing an incredible job just breaking it down to us, and it's getting a little technical. And so, Doug, I want you to treat us like first graders, all right? So we can make sure we get this right as we try to implement it in our business. So we're now up to segment 3 and talking about Regulation D, CF, and A. And Abraham kicked this off with the great question, accredited versus non-accredited. And what a great segue into talking about the regulations, right, Doug?
Absolutely. Well, one of the things that I tell people is that in this industry, we're in such a great spot now. And it is really, most of it's driven by two things: the Jobs Act changes and the changes since then to the programs, because the programs up until the Jobs Act were archaic. They, for example, Regulation D was 504, 505, and 506B. None of them allowed you to generally solicit. And I think when you looked at where we were as far as social media and the internet and all these great tools that could be used to get exposure for a raise and help companies raise money, and not just real estate, but across the entire spectrum of industries, that it really was overdue for some rule changes to free up the ability for companies to go raise capital. So the Jobs Act was monumental. And then the technology. The technology is phenomenal now for running a raise. But for Abraham's question, which is a great question, it is a great segue into this next step and next segment, is there are options now that can provide the ability to raise money from non-accrediteds and be able to generally solicit the public. That was kind of the combination that was hard to get unless you really went through almost a full S1, back prior to, pre-Jobs Act. So when we look at the programs that are available, Regulation D, Regulation CF, and Regulation A, the Regulation D program got upgraded dramatically because they created 506C. And that is an exemption that's available under Reg D. It probably accounts for 90% of our Reg D work. And the big draw with that program is you can generally solicit the public with the offering, but you do need to keep the investment limited to accredited investors. Now, in general, an accredited investor is an individual that makes $200,000 a year and has the last 2 years, $300,000 if it's joint income and they're investing with their spouse, or they have $1 million net worth, and that would be exclusive of any positive equity value they have in their primary residence only. Now, there are other ways for someone to qualify. For example, they recently opened the door for certain Series 7. If you have certain securities licenses, they consider you to be sophisticated enough to be an accredited investor. But the primary way people would qualify is income and net worth. So with Reg D 506C, you can generally solicit to the public with the offering, but you have to keep the investment limited to accredited investors, and they do need to provide appropriate verification that they're accredited. When we start looking at a real estate syndicator that maybe really wants to start building an affinity base that's a large affinity base, and they are interested in the entire retail public being able to invest, now you start really looking at something like either a Reg CF or a Reg A. Now, Reg CF originally started as crowdfunding. I don't actually like using that term because I feel like it confuses people sometimes. They think, Kickstarter, they think maybe donation-based crowdfunding. And I think the way these Reg CF offerings execute now, it's just another way to go raise money. It's just another exemption to file under. The big draw with Reg CFs is that you can generally solicit the public and you can raise money from everybody. So accredited and non-accredited can participate in a Reg CF offering. Now, there are some what I'll call compliance and infrastructure sort of requirements on that offering. The way we like to execute them is we get the legal work done, and we obviously get it filed with the SEC. We also then get you connected with a broker-dealer, and then we'll build the raise portal that'll run the raise. Because there's really two ways you can execute a Reg CF. You can get your legal work done and launch on one of the big platforms, the SEC-approved crowdfunding platforms, or starting in March of 2021, they made a rule change that allows you to execute off of those platforms, but you do need a broker-dealer to administer the raise as an intermediary, and then they're going to administer the raise through a raise portal that gets built. So we were in a bit of a unique position there because we've got the raise portal build capabilities and we can get the legal work done, and we also have the broker-dealers that we can align the client with. So I think, that is another option then for some of the real estate syndicators where it's 5 million or less. So with CF, you are limited to 5 million in a 12-month period under that program for that entity. But I do have real estate clients where, hey, we only need $2 million for this acquisition. We'd like to raise money from everybody, and maybe we don't want to go through a Reg A process. Reg A is really kind of what I'll call the top tier program. Reg A lets you generally solicit the public. It lets you raise money from the entire retail public, accredited and non-accredited. But Reg A is a different lift on the legal side, and it does have more compliance associated with it. It is essentially an S1 filing we're drafting. It does need to go in, that filing along with all the exhibits have to go into the SEC and get qualified. But Reg A, where I see Reg A used is either a lot of times experienced real estate syndicator that's ready to go, move past maybe some of the smaller Reg D work they were doing, and they want to go raise $50 million and build a big real estate portfolio. And Reg A is then, I think, a great vehicle for that. We've also seen Reg A used where that real estate syndicator wants to provide investment choice. And what I mean by that is, hey, we're buying VRBO vacation rental assets, and we want to be able to give the investors a choice. So usually then those syndicators are going to have a platform, a website, and they might have 10 different investment options there. They got a Breckenridge ski condo you can invest in, and they got, something in Mammoth, and they got a Destin, Florida beach property. And then where Reg A maybe fits in well there would be that client wants to raise money from everybody. They want a sophisticated offering, but they want investment choice. And in that case, then a lot of times what we would do is we create a series LLC, and each new asset goes into its own series LLC. So it is segregated into its own legal entity, but we create one Reg A from, essentially at the outset, and then we're doing amendments to that to add each new series. So I think when you look at the three programs, and usually when I'm dealing with people evaluating this, Eric, part of what I ask them is, A, how important are the non-accrediteds? Because I do get some clients that say, you know what, Doug, the people I'm going to raise money, they're going to be 50,000 min subscription, 100,000 min subscription and up. And that's all I'm interested in. I'm interested in people that can cut, six-figure checks or, $25,000, $50,000 checks. That's normally going to outstrip the investment capabilities of non-accrediteds. So then you have to question going through a CF where you got to pay a broker-dealer 3% or going through a Reg A. You kind of maybe have to question whether that's going to really benefit the client if they really are just looking to go to the accredited crowd. What I like to say is, it's great to have all these options, because I was running this business for a long time when there were not these options. And I think having the options now where it's, do you want to raise money from non-accrediteds? And then also just the differences in timing and budget, it's really made a big difference then for clients as far as having choice, as far as what vehicle they're going to put in place.
Doug, if you could state one more time the difference between, the requirements of the accredited investor, because one thing that stands out is that a person can't have that net worth requirement be represented by their equity in their primary residence. And for most people, most of their net worth is tied up in their primary residence. There are investors that, of course, have other properties, but I want to be clear on that requirement.
Yeah, well, and S1 is a registration statement to register securities. If you were going to go public and do an actual IPO, you would be doing an S1. And the other reason why I mentioned S1 is just that to give people an idea of the fact that Reg A is a more expensive process to go through because the legal work is more robust. As far as the accredited investor piece, and especially the piece tied into equity and primary residence, I actually disagree with it. That was really put in place after we had an explosion in equity in real estate back in, I think it was really driven by the 06, 07 kind of, market. And I think what the SEC saw was, well, are these people really accredited if they kind of have what I'll call fake equity that maybe got built into assets? I disagree. Because the way I look at it is, if you've managed your finances properly and you have a lot of equity in your primary residence, or maybe it's completely paid off, that should count, in my opinion. I think with the accredited verification, if it's a Reg D 506C and someone's an accredited investor, there's various ways that they can provide verification. I think the easiest way is they just get either a CPA letter. Most accredited investors are going to have a CPA, probably at least doing their taxes at the end of each year. They can have a broker dealer sign a letter. They can go through a verification service to get verified. Technically, they can provide things like tax returns, but we rarely see that, just because if I'm going to put tax returns up into a portal for an issuer to verify I'm accredited, I might as well just send a form letter to my CPA and say, hey, Jim, you've done my taxes for 10 years. Sign this. I'm accredited. So I think it is interesting, Eric, on the accredited investor rules that, for me, I think that the equity component in a primary residence, I actually think it should count. And because I think it kind of penalizes people that have properly managed their finances and, maybe ended up holding an asset for a long time, or maybe they paid off their mortgage early. I don't think they should be penalized in that regard. That's a legitimate asset on their balance sheet. And in my opinion, it should count towards the definition. And, We might actually end up seeing some changes like that. I mean, I think the SEC is certainly looking at a lot of that stuff on a regular basis as far as rule changes go.
So an accredited investor is required for the Regulation D 506C and are not for the B, or can you just show which one requires them to be accredited, or is it CF that doesn't require accreditation?
Yeah, so Reg D, we normally are looking at either 506B or 506C. Those are kind of the two primary programs clients would go into. The 506B is what I call the old program. I mean, it's still available. It is a traditional private placement, meaning you're not allowed to generally solicit anyone with that offering. It does allow up to 35 non-accrediteds to participate every 90 days. It allows an unlimited number of accrediteds, and those accrediteds do not need to provide any kind of verification. So I think where the B program fits in would be what I call a pre-syndicated deal, or if you want to use the term friends and family, where it's, hey, I got 20 people, I've got substantive relationships with them, they're going to invest in my development project, I'm selling a membership interest, I need an offering and some legal work done, but I'm not going to generally solicit anyone. I think that's where something like a 506B would probably make sense. 506C, now you're really looking at a syndicator that wants the ability to get into the public domain. They want to be able to get on their LinkedIn and their Facebook. Hey, everyone, we're raising money for a real estate fund. If you're interested in participating with us and you're an accredited investor, click here and you can go to our raise portal. The CF allows everybody. You can be non-accredited and invest in a CF. You can be accredited and invest in a CF. But obviously then now you're triggering a little bit more in the way of compliance coming in. You got to have the broker dealer on board. You have to have a transfer agent on board. The transfer agent's job is to record who's purchased securities and basically record all the relevant data related to that transaction. And Reg CF, if you're doing an offering over $1,235,000, you also have to come in with audited financials. So what we find with the real estate operators a lot, Eric, is that it's a brand new entity being formed. So, hey, we're going to acquire this asset. We've just created a new LLC to raise the money to acquire the asset. And in that case, then the only thing that's really going to be audited would be the opening balance sheet. So in that case, then the audit's not expensive. It's a pretty simple, process to get completed.
Is there a minimum balance sheet, or were they looking for just the money to be there to take down the asset?
I mean, initially, prior to the raise, when the audit gets done, it's usually just going to be some starter cash on the company's checking account. Well, we funded it with $5,000 and there's no liabilities. It's a brand new entity. And then, certainly a lot of my real estate clients, they are bringing in senior financing. So if it's a $10 million purchase of an asset, they're maybe raising $3 or $4 million in equity, and they're going to get the balance as far as senior financing from a bank.
What are the misconceptions about crowdfunding? Because I see a lot of people on YouTube actually talking about crowdfunding for real estate, and crowdfunding is what enables you to talk about it to the general public, but you need to be very circumspect in what you're saying that you can do, right?
Yeah, I mean, CF especially has some kind of unique restrictions on what can be said and what can be disclosed outside of the raise portal. For example, offering terms. So usually if you're putting a CF out and you're doing marketing, you're really announcing that you're raising capital, but you're not going to be putting any kind of securities terms or offering terms in the advertising. Now that can be on the raise portal. So when the investors hit the raise portal, the broker dealer, administered portal, then there it can be disclosed what the offering terms are, and obviously in the filing work and the offering circular. So I think with CF, again, you want to get legal advice on that, and I think where there is the benefit of having the broker dealer on board is that between the law firm and the broker dealer, now you have, essentially two entities that are working with the client to make sure that they're doing everything in a compliant manner, because the broker dealer's job there essentially is to administer that raise and be the intermediary between the issuer and the investors and make sure everything is handled properly as far as the compliance.
So in assisting someone and establishing these funds, you because they may not have, a broker dealer. They don't know, they don't know really the inner workings of making this happen. You provide that support. So essentially, they're bringing their network and their reach via, media, social media, what have you, to get the word out that they're raising capital. And the broker dealer then would be the entity is formed. The broker dealer would be the one that would be managing the that capital and acknowledging receipt of the capital, and this is all a very transparent thing because those who are investing in this knows that the money is not going to be deployed to acquire assets until the raise has been completed.
Yeah, I think well, first of all, I really do view our role as being a quarterback in the process. Again, I get experienced clients that come through the process. It's their fifth raise. They understand exactly what to expect, but also have a lot of clients where it's their very first time coming through the process. So I think in all of the offerings that we do view ourselves as essentially the quarterback to make sure that everything's getting put together in an efficient manner. With the CFs and Reg As, but with the CFs especially, since the broker dealer is required, then yes, that is part of what we're doing is getting that client aligned with broker dealers that can serve as their intermediary. Then from there, the broker dealer is managing compliance, and then certainly if there's a minimum offering amount, like, hey, we ideally want to raise $3 million, but if we can at least raise 2.2, we can acquire the asset. Then that broker dealer is going to be coordinating with escrow to ensure, obviously, that you have to have reached that minimum offering amount before they release those funds.
So, in your professional opinion, and let me describe, the typical client that would be a real estate broker, an agent with a great deal of influence, been in the business 20, 30, 40 years, very known and respect. He doesn't have $3-4 million, but he has access to capital. He's an REO broker. He's got, he has access to assets, that is, or relationships in the marketplace of other agents who have great deals for sale. And so what is your recommendation to that person who is doing their first deal and working with you? Should they proceed with, the Reg D 506B if they have like a small network, or 506C if they want to go public? What would be your recommendation?
Yeah, I mean, I think a lot of it comes down to what kind of capabilities do they want from the offering. And sometimes that varies deal to deal. I'll give you a great example. I mean, I've had clients where they do a Reg D 506C because they need to be able to go generally solicit and get exposure for the offering to raise the money, granted accredited only. And then, a couple months later, they might be doing a 506B for an entirely different deal, but they've got a family office supporting them on that deal, or maybe they've just got two really high net worth people they're going to invest, and they don't need to generally solicit. So I think part of what we look at when we start evaluating working with a client is, looking at what kind of vehicle do you want? What kind of capabilities do you want? Because I think that really is going to then drive what program they end up in. If it's, I have 4 guys, they've invested with me before, they're all accredited. That's my cap stack for the project. But I'm gonna be selling a membership interest in this LLC. Well, yeah, we'll probably put them into something like a 506B, just because that's gonna be the most efficient, cost-effective solution to accomplish the goal. Versus say, hey, Doug, we want to raise $50 million and we're going to start building a real estate fund, and we want to grow this thing to be a $800 million fund over the next 4 or 5 years. They may start out with Reg A, knowing that that's going to be a vehicle that's probably going to provide them better capabilities for raising capital, and it's also a vehicle that could be refreshed essentially into year 2 and year 3 with some filing updates. So again, I think it really just comes down to the client and what they're looking for. But again, I will stress, it's just great to have these options now. And I think usually what's nice is there's going to be an option that fits what that client's looking for. And again, sometimes that's going to vary based on what they're looking to accomplish.
Doug, this is really great information. And we got one more segment to go. So we're going to forego Q&A from our guests. My apologies to Matt Damon. We're going to take a quick commercial break. And when we come back, the final segment, folks, we're going to get into the money. How do you make money? How do we make money as real estate investors putting this all together? How do we structure this thing to establish our first syndication? You're listening to or watching The Power Is Now Real Estate Roundtable. We'll be right back.
Everyone knows the power of social media and the impact a strong online presence has in this day and age. But most real estate agents simply do not have the time to manage all the advertising and marketing details, and that's where the Power Is Now Media steps in. We are the answer you have been looking for. Let us help put your brand on the map. We will create customized graphics for weekly full-page ads, social media content, video, and podcast content for you. Sound complicated and expensive? It is affordable and easy. We have the best experts on the job. Go to thepowerisnow.com and find us under the VIP Agent tab to learn more. This is the future of real estate. Join today. Thepowerisnow.com.
And we're back. Welcome to The Power Is Now Real Estate Roundtable. My name is Eric Frazier. We've been talking to Doug Ruark, who is the president of Roundtable Securities, and they focus in on securities for real estate, helping people form syndication to raise capital, to take down big projects. And wow, have we been on a journey? This is segment 4, and it's been highly educational. I mean, I feel like I'm ready to get started right away. I don't know about you, but if you've been in the game 10, 20, 30, 40 years, and you're ready just to operate at another level, why not form a division in your company? You have your property management. Some of you have a mortgage division. Some of you have an escrow division. Some of you even have a title company division in your real estate firm. But what about an investment division where you are creating syndications to help your clients who like, know, and trust you for years take down big deals, 1 million, 2, 3, 4 million, income, storage, you name it. You can do it with a syndication. And Doug, you have done this has been a masterclass, honestly. This has been a masterclass in syndication, and I really appreciate you taking the time out of your schedule to educate us today. And I'm excited about this final segment on structuring these deals and just how do we make money. So how do we make money, Doug? How do we structure a syndication?
Right. That's it. No, people's time is money, right? No one's going to put a syndication together and not get paid. Yeah, happy to run through that. I mean, I'll preface this by saying that, this would be part of the initial part of the legal work. Because every deal's different, and sometimes it may be a debt offering where the client's just bringing in some bridge capital. Most of the time on the real estate, though, we're seeing equity, and in part just because they want equity on the balance sheet, and then also they're usually bringing in maybe construction perm financing or just permanent mortgage financing as the balance of the purchase price and the cap stack for the asset acquisition or project or what have you. So let's just take maybe a typical real estate syndication, for example, and we'll make the assumption that the sponsors, not putting in any capital of their own. Typically what we'd see an LLC formed to raise the capital, and then that LLC would also then be the entity that's purchasing and holding title to the asset. Usually then what we would see within that entity would be, 2 classes of membership interests. As an example, there'd be a class of interest for the investors and there'd be a class of interest for the sponsors. And we would also probably then see a manager entity. A lot of times it'd be a manager managed LLC, and there's a manager entity that's owned typically by the sponsors that is managing the what I'll call asset entity. So then really from there, the operating agreement is really going to be defining then how income is going to be distributed. And so again, typically what we might see would be a waterfall that's going to be applied to lease income or operating income. So it might be 70-30 between investors and sponsor. It might be 80-20. Part of what we might see there as well is maybe a preferred return. So that off of, at the end of the year, off of distributable net income, that there's a 4% preferred return provided to the investor class members. And then after that, 70-30 split between the investors and sponsor. Now, a lot of people are going to ask, well, gee, Doug, how are these percentages set? Well, a lot of it really comes down to what's the asset class, what's the risk, what's the target return. There's various ways to get to a return. So if I've got a client that says, hey, Doug, we really want to hit a 12% annualized return for our investors, well, there's a couple different ways you could probably get there. You can get there with a stronger pref and less participation. You could get there with a more minimal pref but more participation. So I think, again, that'd be part of the legal work, is working with the client to structure those return mechanisms. And then there's typically going to be another waterfall that's going to apply to capital event income, which is, hey, we've sold the asset. We've got an event here where the asset's sold, and how is that going to be applied? And typically you'd see it where it's first paying down debt, then it's going to pay off any invested capital from the investor class members, and again, assuming if the sponsor hasn't put in any capital, and then from there there'd be a split as far as the remaining profit from the sale of the asset. So when it comes to how does the sponsor make money, that's one way, is obviously just participating in the income and any kind of accretive value that gets unlocked at sale. Part of it also would be fees. Management fee for the entity. There's maybe construction oversight or construction management fees if there's maybe rehab work going on, acquisition fees. Hey, the sponsor and the manager did a lot of work to, evaluate the property, vet the property, take it through closing. We're going to take a 2% fee based on the acquisition price. Disposition fee. Hey, we had to prep the asset for sale, market it, take it through the sales process. And again, that would be part of the legal guidance, is what are the available fees that could be taken? What are the market ranges for these fees? And then all that would be memorialized in the operating agreement for the LLC.
Wow, it sounds too easy. And the reality is that, the sponsor, the person who really has the facilities, if you will, or the ability to identify the asset, negotiate the deal, put together the LLC, the structure, do the marketing. I mean, that's sweat equity that they're bringing to the table. They don't really need to have money, but they could also invest themselves in the project, right? Sure. But you just described a scenario where the sponsor could get, an 80-20 split, or maybe a 70-30. The sponsor gets 20%. And this would be of the distribution when it's sold. It could be also of the income, if it's going to be held for income for a period of time. That's how the sponsor is incentivized to keep, to manage it all and to support it all and to keep bringing business.
Absolutely. And, I do have clients where they're going to have capital invested alongside the investors. So it's not always where the sponsor doesn't have any capital investment in, but there's certainly plenty of these offerings, especially the big multi-asset real estate funds, where the sponsor is there. They may not have capital in play, but they're dedicating time and effort to manage the fund. They're the ones bringing the expertise. They're the ones sourcing the assets. I mean, so there's a lot of work and effort there, and that's really where they're earning that. Some people call it a promote, but I mean, that's really where they're earning their 20%, or they're essentially their participation in the income coming off the fund.
So let's say that the sponsor identifies a property, and maybe doesn't identify the property yet. Can the sponsor set up the blind trust and kind of put together something that will just convey what the vision is for this? And I called it a blind trust, but it's not a blind trust, right? It's a blind
pool real estate fund. But it's funny because I really don't like using that term, because then it kind of denotes, well, do the investors know what the fund's investing in? Well, of course.
Right.
And I think too, this then comes down to some of the nuance as far as the legal work, because, for example, I might have a client that says, hey, Doug, 90% of what we want to do is self-storage facilities in the Dallas, Houston, and Austin markets. But every once in a while, we might run into, some opportunity in the multifamily space that we might want to. So part of it is essentially kind of building the box that this fund's going to operate in and making sure you're disclosing everything properly. Because, if I'm thinking that the fund's just going to be self-storage assets and all of a sudden the fund manager is out and they're buying, a commercial office building somewhere, yeah, that could be a problem if it wasn't disclosed. So I think, again, that comes down to some of the legal work and the nuance there, which is building that box that you're going to operate within and making sure the investors understand, what is the asset class, what are the markets, what does the leverage look like, and then what is maybe the leeway that's there to allow an asset or two that maybe falls a little bit outside of the kind of the core scope of the fund's, primary asset class. So those are some of the things that we contend with, which is, how much variance is there in these assets, and how much flexibility does the client want as far as being able to deploy capital in an opportunistic manner.
So Doug, typically, if I'm going to take down, a single family deal, I'm going to do private money. I can get 70, even 80% sometimes, right? But around 70% take down. So I'm using debt, and then I bring in the difference in capital. When it is raising debt, when you have the ability to not even use debt if you can raise enough money, but when does it make sense to create a debt-based structure?
Yeah, I think if it was a situation where the client maybe had existing operations, they had perfected their existing operations, and they just want to offer a fixed coupon investment option to their investors, where that might work, where the investors are going to get a 24-month note, they're going to get 14% interest annualized, payable at maturity, but maybe they're just looking for a different option for their investors. So I've seen that before, where there is an equity participation option, but for people that really don't want to be on board as a member or an equity holder in that entity, that there is an option for them to just be essentially a lender to the entity. The only issue really there is that you're probably going to end up with lower cost of capital by bringing in enough equity to qualify for institutional funding from a JP Morgan Chase. So I think really when I see clients and they're looking at their cap stack and looking at what's going to be the most cost-effective way to set up the capital to acquire this asset, normally it's going to be raise 20% equity, 30% equity, and then get the balance, because now you qualify. Now you're showing up at that banker's doorstep with an LLC that's got enough equity capital where they'll be willing to loan first lien on that asset. So that's why I think most of what we do for the real estate sector tends to be equity offerings, but we have done debt, and I think a good example of that would be just an operator that wants to have a debt option for their investors, where, hey, I just want a fixed coupon every year on a note for 24 months, and I know exactly when I'm exiting, because in 24 months you're paying my principal back, and I've exited from the investment.
So if a person doesn't use debt, and maybe an institutional investor, they run the risk, because the amount of money they need to raise, of not meeting the deadline, the timelines, unless they're doing a blind syndication.
Yeah, I think that is something that they would have to look at if they, and I will say I've got some clients where they don't want any debt on the books. They're willing to pay a little bit more in the way it costs of capital to have an all equity cap stack. And now they don't have to worry about any kind of default, because there's no lenders involved. There's no liens on the property. So, but I think that's something that the client would look at, which is, and look, by the way, there might be a kind of a best of both worlds scenario for them, which is, look, Doug, I'd rather not have any debt on the property, but timing wise, we want to leave open the option that if we've raised 30%, and if we're starting to bump into that closing time frame, that we can bring in an institutional loan to at least take the property down. And by the way, they'll probably then keep the offering open, and they'll just keep raising equity, and that equity is just going to go to pay down the debt.
Yeah, I like that idea that you can move on the transaction with equity or with a loan, and then continue to raise and pay off the debt, so it doesn't pose any risk at all to the investors. And I think that is what any investor is going to be concerned with if there's debt, that if the project isn't completed, the bank ends up owning it, or they have to come up with more money to save it, that kind of thing. How do you address the risks associated with these type of transactions? I mean, is that included in the documents, the documentation that is created? What do you call it? The
Private placement memorandum.
Yes, the private placement memorandum.
Yeah, that's the key purpose of that document. Or if it's Reg A, the offering circular, but it's essentially the same thing. It's a disclosure document, and yes, that's a big piece of this process and a big piece of the work being done, which is making sure that investors understand all the risks, and that might be things like unforeseen environmental risks that now all of a sudden create a big problem with the asset, or at the very least an unplanned expense. Certainly default risk that, if we default on our loan, there's covenants where the lender's going to come in and, and take control of the property. So I think that's a big part of the work that gets done, is creating a proper disclosure document, whether it be a private placement memorandum in a Reg D, offering circular in a CF or Reg A, to make sure that everybody's got full disclosure. And, if for some reason you had an event or an issue, the goal is protect the company, that, well, it was disclosed to you that, we might have cost overruns. That's actually an interesting one because, after COVID, when you had a lot of these the material inflation happening, plywood tripled in price and all this stuff, all of a sudden you've got projects midway through where now their budgets are completely different from when they started. So yeah, I mean, all that's the purpose of, in fact, really this process is protecting the company that's raising the money, but in a way also protecting the investors to make sure that they fully understand the risks, and making sure then that they have the ability to determine, is this an appropriate investment for me?
Well, the private placement memorandum, I can definitely see the value of an attorney creating that document. And then as I think about, just what's happened recently in Texas, where, a flood has just destroyed everything in its wake. If anyone was raising capital to build a structure, income, storage, what have you, and it was destroyed by a natural disaster, does the private placement memorandum cover things like natural disasters? And I'm wondering now, too, is there insurance available for projects in the work? I mean, yes, I guess there is construction insurance,
Yeah. But these are all valid disclosures, obviously, for a lot of these projects. So certainly, acts of God, acts of, extreme weather events. I mean, all of these things are typically, going to be applicable risk disclosures in these types of documents.
Now, also too, the person creating the LLC, I mean, he has options, or she has options. They can do an LLC, they can do a limited liability LLP, right? A partnership. They can do, and then what about Delaware statutory trust and people who are like moving funds from a 1031 exchange? Are there limitations, pros and cons to the various types of entities that could be created that fall under the regulation?
Yeah, well, and again, that's all then part of the legal work that's getting done, because again, it's part of creating a solution that's going to meet the client's needs. I would say most of our real estate work is going to be LLCs. We've certainly done some LPGP structures. Haven't really done much in the way of the DST work. That's kind of its own specialty. But I think, it really then just comes down to the client and what are their goals. I mean, if it is a client that's going to bring in some 1031 capital, there's probably going to be a certain strategy. If it's a client that just wants a simple vehicle to raise money to do an infill site development project, that's going to drive probably something like an LLC or maybe an LPGP structure. That's where, I would call it the initial 10 to 20% of our work. A lot of that is working on what is going to be the entity that's going to be formed, and what does the structure look like. Those are all, and they're all really then just, based on what is the client's project, what are their needs, again, what's going to be the best solution to fit their needs.
Okay, so Doug, I want to get started, and the investor portal that you create for me, that really provides me everything I need, right? Because if I'm getting started with this, I do have, expertise in marketing and writing copy and that kind of things, but I don't have the legal expertise. And so, to what extent, I mean, do I just need to write the check and you do it all? I mean, how does this been done for you?
Portals, let me say this: the portal. The best way to describe the portals is it's an administrative tool for managing the offering. So the offering launches, and you're now driving your prospect traffic over to that portal. And assuming it's an offering like a 506C or CF or Reg A that allows general solicitation, you're out on your LinkedIn, your social media, you're doing webinars, press releases, but you're getting exposure for the offering. You're driving that prospect traffic to the portal. The portal will then have a front end engagement website, and it's there to engage them for, let's say it's a real estate fund. It's there to engage them for the fund, the asset class. Here's our management team. Here's why we think this asset class is going to be advantageous. And then it'll have the appropriate access to the offering circular, the SEC filing work. So it's going to, track access to that. All right, Doug's read everything he needs to read to invest. And then there'll be an invest feature that's going to take that investor through the investment process, track them all the way through, archive everything properly. And then, with these portals now, they're all going to really have back-end cap table and investor relations management. I mean, we have our own internal Reg D system that we use, that we built 10 years ago, that we've been obviously have new versions coming out all the time with enhanced features. But for the CFs and Reg As, we're normally then integrating transfer agent platforms, because the transfer agent's required in a Reg CF or a Reg A. But I think that's one of the things that just in general has been a huge change, is the technology now, because it's essentially then a hands-free process for you as the sponsor. So for you, it's really just get exposure for the raise, because once you've driven me to the portal, if I decide to invest, the portal's going to handle that process.
So the portal does everything for me. If I literally said, okay, Doug, tomorrow, man, 2:00, you and me on the phone, we're going to get started, right? And everything that needs to be done, you're going to help me. I don't need to be an expert on the copy that's going to go out, the media, the marketing, all that stuff. Your team helps put all that together, so that at the end of that process we go through, I have a portal, an investment portal to direct people to get all the information they need. And I can just be the spokesman and the promoter, talking about it, what a great opportunity it is, sharing it with friends, family, and the audience, that we're raising $5 million or $3 million to focus on income multifamily units in the state of California.
Yeah, I would say here's the thing: the portal is going to go hand in hand with the legal, because obviously you got to have the offering in place and your legal work done and your SEC filing work done to launch a raise. So, the portal really is going to be built out alongside the legal. But when the legal's done and that offering's ready to launch, the portal's ready to launch. And, really from there, I mean, a lot of it depends on the client I'm working with. I have a lot of clients that are going to be able to create their own marketing content. They're going to be deploying webinars, press releases. They're out on their social media. We certainly can, be brought in to review that content.
Right.
We're also going to build that front end engagement page content, because that's really the key thing. I mean, a lot of the stuff you're going to put out like on LinkedIn to drive traffic, it's going to be quick. When you look at LinkedIn, you got that little box, right? So maybe it's a short video, but it's going to be quick hit content. Hey, we've got a real estate fund. We've got a really unique asset class. We think it's a great opportunity. If you want to learn more, participate with us as an investor, click here. And obviously that click here is going to take them to the portal. So I think releasing the sponsor from a lot of the administrative work of managing an offering, I'd say that's one of the biggest things with the portals. I think the other thing is just handling that security sales process in a compliant manner, tracking everything, archiving everything. That obviously is important as well. But I also think too, having the ability to manage the cap table and manage investor relations using technology is just as important, because I get a lot of people that say, well, Doug, what, if I do end up after a couple years with 4,000 investors in this fund, what's that like managing them? Well, with modern technology, it's pretty straightforward. So I think the tech has kind of touched a lot of different things. It's certainly touched the engagement and the security subscription process, but it's also dramatically enhanced and touched the investor relations side as well.
Wow, Doug, I'm excited, man. Just learning about this, and I'm ready to implement. And I certainly hope those who are watching are saying, "Listen, I need to do this." 20, 30, 40 years in the game, maybe even 10. I don't even know. I mean, even someone new just getting into real estate. Maybe they're not even in real estate; they're just real estate investors, and they own a lot of real estate, and now they want to go to another level instead of doing everything on their own, pulling their funds together. So can you just talk about the realistic timeframes, say from first meeting to the portal is up? What does it take? How long does it take to put this all together? And this would be a great opportunity to talk about cost, because obviously there's legal work involved. This is not for the newbie in real estate or for the agent struggling. This is for someone who's achieved a certain level of success in real estate. And you're going to need to be that person anyway to have others follow you and give you their money, right?
Yeah, absolutely. Well, I think as far as timing goes, for a Regulation D offering, my standard guidance is 30 to 60 days. Now, if I have a client that is under a time frame issue, meaning they got a contract on a property, it is possible to get it done in under 30 days, but they've got to be really responsive, obviously. And if it is that situation, and I'm on, let's say, an early sales call with them, like, well, we're thinking about putting a property under contract, probably what I'm going to say is if you want to use us, I would ideally like to get engaged and started on your work prior to you putting under contract. Because if you already know, hey, we've got it down to these 2 or 3 assets, there's a lot of work we can get done preparing that offering to get ahead of the game, so that you have maximum time to go syndicate capital. As far as general costs, for a Reg D, your legal work, 18 to 20,000, somewhere around there. A lot of it depends on what we're doing for a client. And by the way, part of it also comes down to, is it a repeat client? Because if I've got a syndicator I've worked with multiple times in the past, I've got some efficiencies there. I've probably got a lot of legal work I can reuse, especially if it's the same asset class. Portal builds for Reg D, usually 4,000 for the portal build. That's the front end website build and the back end software build. And again, these are general costs. I mean, I think I've had very sophisticated Reg D offerings where we had to charge more to cover the time. And I've had some that were super simplistic where we charge less. So part of what we'll do is we will do an intake call with the client, a prospective client at that point. And we'll really evaluate, what is it they're looking for us to do. And obviously then we'll be able to then set an appropriate, fee level for that, because we are big fans of flat fee work for the securities offering preparation work. That way the client has budget certainty coming in. And there's also built-in incentive for us to get them through the process efficiently, because we're not charging hourly. So it's not, oh, Eric wants to talk about his project for 2 more hours. Okay, well, let me hit the timer. So we're big fans of that, because I think for a lot of these clients, budget certainty is important. Hey, we know if we pay X that we're through the process. Reg CF, we're 20,000 right now for the legal work, portal build, and introduction to the broker dealer. But they should factor in another, I'll call it 5 to maybe 8,000, and that's just going to be engagement fees to the broker dealer, transfer agent, getting the escrow account in place. So the CFs, again, somewhere in that range. And again, this is where I like doing exploratory calls, where if I'm on what I'll call kind of an initial sales call, is I'm going to try and kind of fact find some things, because if it's a company that's got 4 years of operating history and they want to do a $5 million CF, they're going to need audited financials, and they're going to need 2 full years of audited financials. That could be, a reasonable expense right there. So part of what I do and what the firm does really on our initial I'll call it sales calls, but kind of initial intro calls with prospective clients, is really kind of sort through some of those things. So they do have an understanding of what they're looking at as far as costs. CFs, 60 to 90 days. There's just more going on preparing those. You got a broker dealer that's on board. They're doing due diligence. You got a transfer agent. You got escrow accounts. You got payment rails being set up that involve credit card merchant accounts. I mean, it's a more sophisticated offering. So I think with the CFs, it's wise to plan for a little bit more time on the prep side. And then Reg A, since Reg A is a more sophisticated offering to prepare, it requires much more time and effort as far as the legal work. We're $50,000 right now for a Reg A. That's the legal work, submittal to the SEC for qualification, access to our ecosystem of other vendors, and then a Reg A raise portal build as well is built into that fee. And timing wise, my default there, 90 days to get the legal work done and submit. If we don't get any comments back from the SEC, which is always the goal, we'll usually then be ready to request qualification within, I'd say, 2 to 4 weeks after that. So with the Reg A's, you're more looking at definitely planning ahead. And that's what I always kind of counsel people on with the Reg A is if you are planning on a Reg A, get started early. It's not something that you're going to put in place in a couple weeks. It is something that requires more time. There's just more legal work, more sophisticated offering. And obviously, then it does need to go through that SEC qualification process.
Doug, I thank you for that very, thorough review of the cost and, just considering everything involved and the importance of doing it right to protect your reputation. I think that the costs seem more than reasonable for every type of regulation you're talking about. It just seems not just reasonable, but for the seasoned real estate professional who has a business, who has a following, who's experienced a degree of success, it's affordable. This is not for everybody. This truly is for the pros, the established real estate professionals who have an audience, who have a following, who have a book of business of past clients and people that they're working with. Now, there is, even if it's affordable, it's still, an investment, $25,000 to $50,000. Can you talk about success and failure? What would be the number one reason why, after investing this money and to raise money for a project, that many of them don't achieve the goal? Many of them shut down or fail.
Yeah. Well, one reason would be they have a very high minimum offering amount. So, hey, we're going to purchase a manufacturing plant and, we need $20 million, but at a minimum, we need $15 million. So they definitely need to raise pretty close to their maximum to have a successful offering. So that certainly can be one. Now, actually, one of the things that I think is interesting about when you start looking at real estate funds that involve smaller assets and it's going to be a multi-asset fund is that you can you've got a pretty wide range between the minimum and maximum. And an example of that would be a VRBO vacation rental fund. Hey, Doug, we're going to be buying $500,000 to $1 million, resort type or beachfront or mountain, ski type assets. And, we're going to rent them out. And we want to go raise $20 million, but we can start building a portfolio with a couple $1 million. So they're going to have a pretty reasonable chance of success. Now, granted, do they raise the full 20 million? I don't know. It'd remain to be seen. But if they raise 12 million, they've raised enough to get that portfolio moving forward. And I think for a lot of the initial people that are putting together a fund, for example, that's kind of their primary goal. Is we're not trying to raise $400 million in our first round. Let's just get some assets on the portfolio and let's start building a track record. That way we can then start scaling. So ideally maybe we want 100 assets on the books, but if after this first round we can at least get 30 or 40, great, we got track record building. And we're able to then prove out our skills at managing these assets. And that makes it easier than when you go into a second or third round to raise more money.
Wow. What about advertising and sponsorship? I mean, promoting it, is that a reason why some funds don't make it?
Absolutely. Well, and I think that's part of the reason why we always try and provide some guidance on that. And again, I think a lot of it comes down to the client. I do have clients that are sophisticated on marketing. They've got a big affinity base. They're gonna be able to handle that piece. But I also have some clients that either don't have that talent or skill set or affinity base there, or maybe they're just looking to add some additional horsepower. And in that case, then now you start looking at bringing in some of these specialist marketing firms, investor acquisition marketing firms, where they're going to set up a marketing and PR campaign to help promote the offering alongside the sponsor. And those are certainly things that we can look at. We've got a big ecosystem of vendors that all dovetail into these offerings, whether it's broker dealers, transfer agents, audit, investor acquisition marketing. So again, I kind of look at that on a case-by-case basis, because you might end up with someone like an Eric that's got a big affinity base where you're probably going to raise the money right from that affinity base and probably not need external help. But then there's also the client that might need that external help.
Well, the Powers Now is uniquely positioned, I think, to raise capital and to just promote great real estate projects, because that's what we've been doing for the last 16 years, leading the conversation about real estate. And I have to say, Doug, this has been, I think, one of the best shows in the history of the Powers Now media. 16 years. It has been so comprehensive, and I'm so glad that you were able to make the time. We began this conversation last year around the beginning of the 2024, and we're just now making it. Thank you for just some great information. And I want to bring in Guy Allen. He has a question, I'm sure, and for a final question and a comment. And then I want you to provide some contact information for those who are listening to the podcast, Doug, to reach out to you and call you. And then for those who are watching, well, you see it on the screen. You can reach Doug by email, go to his website. But Guy, final question and content, and then I'm going to have mine, and we'll let Doug have the final word.
Thank you, Doug. You're a trooper, man. You've been hanging in here with us. We've been shooting them at you there, but you've been answering all those questions. My question basically is, what would be better, a syndication or a REIT, a real estate investment trust? And maybe what is the difference? Why would someone do one versus the other?
Sure. Well, I'm particular about the term REIT because to me, REIT means you're looking to form it so it is going to be a tax advantaged entity and fund structure. And kind of the big thing there normally is that 90% of the income is going to be distributed to the investor shareholders. So we've done REITs before. Most of what we do, I would more term private real estate fund, which is it's going to be a fund. It's going to raise money. It's going to acquire and manage assets. But the sponsor wants 20%, 30% participation in income, which is not going to fit into a tax advantage REIT structure. Syndication to me, I think, again, a lot of it comes down to the goal of the client, because, for example, I might have a client that is interested in putting a fund together, but they have maybe a really unique project or acquisition, and they're going to just drop that into its own LLC and do its own syndication for it. That, hey, Doug, I normally do self-storage. That's my bread and butter. That's what I know. But wow, I've got this marina deal that's just, perfect. And maybe they've partnered with someone that, maybe has some specialization there, where maybe they are going to put that into its own LLC and do its own offering as a standalone raise and a standalone opportunity. So I think, Guy, a lot of it just comes down to the client and what are their needs. I think, with the fund structures where you're raising money into a fund, you have one offering, but that offering is providing capital to buy multiple assets. Again, you get diversification for the investors, but you're also only creating one offering really to go raise money that can potentially fund multiple asset acquisitions. So I just comes down to the situation with the client. I get plenty of clients where it's just a unique deal. We got an infill site development project in this, really unique part of LA, for example, or whatever it is. And, we're not going to try and put this into a fund because it's its own unique opportunity. And we're just going to create that as its own offering within its own entity.
Gotcha. Thank you so much. Appreciate your time.
Sure.
Guy, thank you so much for joining me on this special interview, and for all of our special guests who were able to participate in today's Q&A. I really appreciate your time. And Doug, I tell you, this interview has exceeded my expectations, and in terms of the information you have shared, the knowledge, and I certainly hope that everyone watching or listening to the podcast, if you are a real estate professional I want to ask you, what are you doing to take your business to the next level? What are you doing to become a trusted advisor and helping people to build wealth? There's nothing wrong with just selling real estate, representing buyers and sellers, and you can do that until you retire. But there is another level here. There is another level for our industry. And I'm certainly seeking to operate at the highest level, maybe because I'm getting old. I'm just getting old, and I don't want to, deal with the daily grind anymore. I just want to provide great advice and connect people with great people and to do big things. I mean, who doesn't want to do that? I mean, that's what I want to do. So I hope that's you too. Doug, I want to give you the final word. The final word today. This has been so great, such great information. If there was just one piece of advice you could leave our audience outside of contacting you immediately if they want to get started, what would that be?
Well, I would say this. I just feel like it's an exciting time in our industry because, again, the rule changes that have happened, the technology that's available now, I just feel like it really empowers people to be able to go raise money much more effectively than 15 years ago. And I think then when you start looking at someone in the real estate industry where they've really built a lot of expertise and specialization in a certain market or a certain asset class, and like you said, they could continue just, selling real estate and brokering, but that asset they have, that knowledge they have can absolutely be deployed into something like syndications or like a real estate fund where now they've got an entirely separate aspect of their business. And by the way, an aspect that's going to be bringing residual income to them for as long as they hold that asset. So, and I just appreciate being on here. Like you said, we've been interacting for a while now, and as I said, I'm at a point in my career where I really enjoy this. I enjoy educating, and I enjoy seeing people empowered to go raise money and improve themselves. And so I just appreciate the opportunity to be on here and share this knowledge.
Doug, I appreciate you, and it does shows, man, your enthusiasm and your expertise. It's really, amazing. Can you provide your telephone number and email address for those who may be listening to the podcast or reach out to you? And again, for those who are watching us, it's right there on the screen below. Click on the screen. It's in the show description if you're watching on social media to reach out to Doug. And oh, by the way, Doug, we need to provide the special. Can we provide the special? Are we good with that in terms of the discount?
Yeah, absolutely. So any listeners, anybody within the Power is Now affinity base, mention that, and we're going to do a 10% discount off of legal services for you. And then you can reach me directly at 720-586-8616, and that will bring you right to my desk. I want to personally handle anyone coming out of the Power is Now affinity base. I want to deal with them directly and make sure they get exemplary service. And then our website, which has a lot of information on the firm, but also on these programs, is redrocksecuritieslaw.com. And that site does, again, have information on the programs, our services, but I am more than happy to do calls with prospects. Again, I look at our role as being quarterbacks, but I also look at my role as being an educator and making sure that people understand what are the options available to be able to go do this and do it properly and legally.
Doug Ruark, president of Red Rock Securities. Man, thank you so much for being here today and sharing your expertise. Now, we need everyone to know that the views and the opinions that have been expressed here today on this program are for educational and informational purposes only. They do not constitute legal or financial or tax advice. Get with your attorney, get with your CPA. Please consult your own advisors before you make any financial decisions. That's what I'm going to do. So, this has been great information, and I really believe that anyone in real estate that is serving the general public and want to go to the next level, they should do it now. In fact, that's what the Power is Now is all about. Taking action on opportunities. Please download our TV app, Power is Now TV, available on any Android or mobile device. You can watch all of our Real Estate Roundtable shows on our website. We are also on social media, but you will not be able to watch the long form content on social media, only on our website, only on streaming platforms, Apple, Roku, Fire TV, streaming platforms. So download the TV app today and get educated about real estate. Well, remember, we are at our best, folks, and we maximize our success when we act now. The power is now to build wealth in real estate. Thank you for watching. We'll see you soon right here on the Power is Now Real Estate Roundtable.
Everyone knows the power of social media and the impact a strong online presence has in this day and age. But most real estate agents simply do not have the time to manage all the advertising and marketing details, and that's where the Power is Now Media steps in. We are the answer you have been looking for. Let us help put your brand on the map. We will create customized graphics for weekly full-page ads, social media content, video, and podcast content for you. Sound complicated and expensive? It is affordable and easy. We have the best experts on the job. Go to thepowerisnow.com and find us under the VIP Agent tab to learn more. This is the future of real estate. Join today. thepowerisnow.com.